Supplementary list, item 37 for pronouncement of judgment.
In view of the above discussions, we are of the considered view that the conclusions reached by the learned single judge in the judgment and order dated 8/11/2023 is not erroneous and accordingly would not call for any interference. The writ appeal was dismissed. Most sign accordingly.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 17.
May I please, your lordship? Lordship, in item number 11, we will file the affidavit for service on the respondent, thus the service today itself. May I pray the matter may be taken up any other day along with our affidavit, lordship? 11.
When concept of the plan, faithful and granted, we stand to file an affidavit regarding the service upon the respondent.
Obliged.
Lordship, item number 9, Lordship, I have taken step by way of Dusty and I am going to file affidavit today itself, Lordship.
Same order.
Obliged.
Mr. Majumdar,
Yes.
this writ appeal you have preferred against the judgment of the learned single judge, wherein the learned single judge has interfered or not interfered with the order of the labor court.
Labor Court, Lordship.
So we have doubt about maintainability of this writ appeal, intra-court appeal. Since we feel that the learned single judge has exercised jurisdiction on Article 227.
Lordship, it may come up any other date. Today, in fact, I am not prepared to argue. Fine. Fine.
As per the office letter. New affidavit regarding justice notice of service upon the respondent has been filed by the concept of the appellant. It stop. Concept of the appellant prays for and granted a week's time to file affidavit regarding the justice service upon the respondent. So, having noticed that the learned single judge has passed the interim judgment while adjudicating an order passed by the learned labor court. District
Labor Code.
Labor Court, Dibrugarh. I'm a PCV of the opinion that the learned single judge has exercised jurisdiction on Article 227 of the Constitution of India and against the impugned order, intra-court appeal is not maintained. Learned consent appearing for the appellant. I submitted that he will address the court regarding the maintainability on the issue of maintainability of this intra-court appeal on the next date of his list after a week.
Adjournment request from item number 18 to 26.
May it please the lordships. Malas, I beg to mention item number 18 of today's list, Malas.
Adjourn.
Malas, can a date be fixed in the matter? Can it be taken up on 12th of November, Malas?
November,
November, 12th,
which date?
12th.
12th of November.
Oblige, Malas.
May I please, I beg to mention item number 21, my lord.
21.
21,
Yeah.
my lord. Oblige.
Yes,
May I please lordship, I beg to mention about item number 26 and 27. They both, as my senior is currently unwell, so with the consent of the other party, I pray for adjournment for.
they put the. Two weeks. 26, 27, 2 weeks. Yes.
From item number,
Madam, what about 28? You are appealing for Mr. Kayal or something else? Or somebody else?
I am appearing for Mr. KL in item 28 and 29. I beg to mention these items, can it be taken on 14th of November? I have taken the consent.
14th. 14th of November.
Much obliged.
May I please lordship, I beg to mention item number 25, lordship. My senior is out of station.
Adjourn.
from item number 30 to 36.
May I please your lordship, I beg to mention item number 36, adjournment. Yes.
You know, moved on the application.
Yes.
Adjourn.
Any other request?
Right, Mr. Lord. My lord, the lottery matters. This time we have filed an application seeking impleasement and alteration. We'll be praying for a similar order, my lord, tomorrow, my lord. Those, my lord, once in a year, unlike those regular lotteries. Tomorrow, deep look.
May I please, His Lordship? Lordship, I beg to mention an item for listing Lordship, fresh matter, Lordship. On day after tomorrow, Lordship.
Why, what's the urgency?
Lordship?
What's the urgency so much?
Lordship, the matter was filed on 22nd of October, Lordship, and it has been almost in a week, Lordship. And vacation is coming, Lordship.
After
Lordship,
what vacations?
Lordship from
Only you have the 1 day vacation.
Kali Puja, Lordship. Lordship, kindly take it on
After
30th.
Diwali. After Diwali. Laga dena. Next week, the week commencing from 4th.
Yes. Oblige, Lordship.
Make use of it. I pray for listing of 2 new matters regarding land acquisition. The urgency is that the project work may start. We have, the eviction has been done last week. Lordships may kindly take it up on.
Revision has already been.
Eviction is done. Now the project may, we are told that it may start anytime this week.
Oh, how can we stay the infrastructure project?
Anyway, the day after tomorrow,
Not there. After the 4th.
Then on 4th.
week commencing.
Listen, Lordship. Lordships, I'd like to mention for listing of a fresh motion, Lordships. No, for day after tomorrow. We
Urgency,
have challenged the legality and validity of the Missing Autonomous Councils Amendment Act.
but of the act itself.
Yes, Lordship. And similar matters are pending
The act was framed in which year?
2001, 2005, and 2008. Whereby
week commencing from fourth.
Because Lordship, there are similar matters which are pending.
We have ordered for listing, but in the week commencing from fourth of November.
Much of it.
Daily list for orders, item 1.
May I please, Your Lordship?
Your Lordship may look into the last order dated 29/2024.
Yes, sir. Lordship, my senior is on the way. So,
On the way,
yes, Your Lordship. Kindly,
password for the time being.
at 2, Lordship,
Can't say
deeply obliged.
password for the time.
Item 225.
Lordship, in this matter, Lordship, my affidavit is being filed, Lordship. However, I'm
Your-
having 2 extra copies, Lordship.
Yours,
My affidavit is being filed, Lordship. I'm having 2 extra copies, Lordship, to place before your Lordship.
extra copies of what?
I mean, the copy of the affidavit.
It's after a week.
Obliged.
Item 6.
Respondent number 1 has not been served.
But the service is not complete. Neither ID card nor the
Service?
service is not complete on respondent of 1, Malad. But in the,
Steps.
but in the state petition also, we have taken steps, but he refused to accept. There is an affidavit to that effect.
Who has refused to?
The respondent number 1, Malad.
Respondent number 1.
1, Malad. In the state petition, that is IA number 3787/2023. We have filed an affidavit after effecting the dusty service, Malad. He refused to accept. But this time also we'll try by dusty, Malad.
Yeah, notice issued to the respondent number 1. The waited since long. The concept of the appellant is directed. Learning concept of the appellant is directed to take fresh steps for service of notice through dusty is known. Requisites be filed within a period of 1 week. On filing of the same, let notices be issued to the respondent or returnable of 4 weeks thereafter.
Item 7.
No, yes, state. Which is this department?
PNR. Paper publication.
Yes,
PNR.
Mr. P and D. P and R D department.
My lord, PNRD department has their own standing council, my lord. PNRD.
Ama, more handy. Handy.
And this thing. Okay. This court by order dated 18/9/2024. Granted time to the appellants. To the appellants. To cause service of notice upon the sole respondent by publication. To stop. The complaints report regarding publishing regarding publishing of the said notice in the newspaper has not been filed. 10 days time is granted to do the need to list after 10 days.
Item 8.
Respondent number 5 has not taken any steps for that.
My senior is out of station, so today I will
What
take the
steps? The
decision.
senior is not supposed to take steps.
Today I will take the step.
1 and 5 words, huh? Oh, yeah. Yes, sir. Remaining respondent, 1 and 5 appear, the remaining sir, everything government का भी है. 2 के लिए Mr. Gogoi will appear. One and five. will be Secretary, sir, number two being Mr. Gugoi.
Hello, respondent number 5 is deputy commissioner, but district commissioner, we have filed our affidavit.
Respondent number 5 is the deputy commissioner. What about chairman municipal board, Alakandi?
Fine.
One, two, three, four,
They have
What
next
is-
is upon respondent number 6, madam.
Two के लिए Gugoi appear करेंगे sir. Three,
What about 3,
three तो उनका
Panchayat Rural Development Department?
and
NRD department have their own standing office. NRD, upon
three है. Four and five के लिए sir वो steps हैं, but three, two and three can be.
NRD commission is
Mr. Gugoi is there for.
So Gugoi, put in appearance on behalf of the respondent number 2. And 3 के लिए कौन आएगा?
Mr. Dr. itself.
Mr. Gupta is appearing on behalf of the respondent number 3.
NRD.
Mr. Sharma is appearing on behalf of the respondent number 1 and 5.
1 and 5.
1 and 5. Let notices, 1 and 5. Learned counsel for the petitioner is directed to take steps for service upon the respondent number
4 and 6.
4 and 6. Within a period of 1 week on taking such steps, like notices be issued to respondent number 4 and 6, returnable 4 weeks there, 6 weeks thereafter.
Item 10.
Item 10, respondent number 6 is not served.
Yeah, please, your lordship. Lordship, I'm for the appellant. Lordship, pursuant to the last order, we were to take fresh steps. Lordship, we have not yet received the AD card back, and the dusty notices, we have received the dusty notices. We are yet to furnish the copies.
Await return of notices of the respondent number 6 for 2 more weeks.
Item 12.
Service is not complete in respect of respondent number 6.
Respondent number 2.
Notice my register respondent 6. Respondent 6.
I was thinking of praying for a date for hearing.
12. 1 and 5 appear. 6 के लिए
We may be allowed to take dusty service also. Man.
notice or something.
People already registered post with AD.
Dusty service, he stays in this school.
Okay. Notice issued to the respondent number 6 is already served till date. Notice issued to the respondent number 6 through registered AD has not been served as the acknowledgement of service of notice has not been received. Then it cancelled for the appellant. Paid for and granted opportunity to get the notices served upon the respondent number 6 through Dusty, which took between 65 within a period of 3 days on filing on the same that notice to the respondent number 6 returnable 4 weeks thereafter.
Item 13.
Please have industrial party.
As per office note dated 24,
Yes,
as per office note dated 24/10/24, SR is awaited upon respondent number 2, madam. Neither ID card nor answer notice has been received back till date.
Industrial party, no matter. Very good.
as per the office report. Notice issued to be Respondent number two has not been served till date. Then it consent for the await return of notice of the respondent number two for 2 more weeks. It is noticed that this writ appeal is filed against the interim judgment passed by the learned single judge, adjudicating the order passed by the industrial tribunal Silchar. I'm a procedure of the opinion that that learned single judge, while adjudicating the order passed by the industrial tribunal Silchar, has exercised jurisdiction on Article 227 of the Constitution of India. Hence, intra-court appeal against the interim judgment is not maintainable. And then concept of the appellant may satisfy this court, place for and granted time to satisfy this court regarding the maintainability of this writ appeal. List on list on so and so.
It was a practical.
Satisfy us.
227 on a right.
Item 14,
Lordship, by office note dated 23/10/2024, neither ED card nor answer of notice has returned. Service may be awaited, Lordship. In the meantime, the interim order dated 13/9,
Service, then notices have not been served.
No,
neither ED card nor answer of notice has returned. It may be awaited.
29.
Await return of notices of the answer respondents for 4 more weeks. Interim order passed by this court. Interim order, if any, to continue till next date.
Obliged.
item 15,
May it please your Lordship.
19.
Await return of notice of answer respondent for
For respondent number 1, Lordship.
the respondent number was 3 more weeks.
item 16,
Well, in this matter, as per the office note dated 23/10/2024,
You have not taken this.
provides that no steps has been taken, but I have already taken steps on 4th of October. And perhaps the other side is appearing, my lord.
Respondent number and Mr. You are appearing for?
He's for respondent number 1, my lord. I'm for respondent number 123.
How many respondents are there?
Look, there are 9 respondents, only 9 is left.
Otherwise, all are served.
All are served, my lord. Lordship can take up this matter for admission on 5th, if not inconvenient, my lord.
9.
On 5th.
But if the notice has not been served upon the respondent number 9 there.
Then in that event, my lord, let us wait for a week. In the meantime, they may.
Return of notice of answered respondent. But the officer reported that
No steps.
no steps have been taken for effecting service of notice upon the respondent. Mr. Das has submitted that steps have already been taken and notices upon the respondent number 1 to 8 has already been served.
Yes, please. No.
1, 2, and 3 appeared on caveat. I'm appearing for 1, 2, and 3. I appeared on the first day. I was on caveat.
Only 8 and 9, my lord, notice was issued, my lord. So far as 8 is concerned.
4, 5, 6 are government
Eight, nine.
responded by this court, okay? They are 7 तक appear कर रहे हैं. 8 and 9 के लिए notice है. So 8 appear करें.
As per the office reports, the concept of the appellant has not taken any steps for service of notice upon the respondent number 8 and 9. However, Mr. Das has submitted that the steps have already been taken on 4th of November, the 4th of October 2024. and 24. Ms. Swanso is appearing on behalf of the respondent number 8. Hence, only the service of notice upon the respondent number 9 has not been affected. Let the affected await return of notice of respondent number 9 for 1 week.
1 week.
Or 1 month.
The interim order.
There is a status quo order.
Status order, if any, shall remain in currency till next month.
Deeply obliged.
Item 17.
May I please your lordships? In this matter, Your Honor, we have filed an appeal in the month of May.
Month of?
In the month of May, Your Honor, against the order of a single judge. Unfortunately, Your Honor, on 4th of August this year, the sole appellant expired, Your Honor. As such, we have filed a petition for substitution of the.
Matter comes upon, yes, do you have any?
We have not been served the copy, my lord.
No, we have served.
Legal heirs of appellant to be taken on record. Do you have any objection? If the matter comes upon for consideration of the application preferred on behalf of the was expired on 4/8/2024. The copy of the certificate is enclosed along with his application. Having taking into consideration the above fact, we deem it appropriate to substitute the legal representatives of the appellant, sole appellant on record. Amended cost title to this effect be filed in the connected writ appeal within a period of amended cost title.
54, within a period of 54 days, we have filed.
To be filed within a period of 10 days from today. Stop. On filing of the same, necessary corrections be made in the CIS portal, in the CIS portal. I dispose of IA number 325/2020 is disposed.
For admission, item 19 and 20.
Lordship, may I kindly pass on for the time being, your lordship.
What happened? What you have done?
Your lordship,
What steps you have taken
our Mujumdar is on legs, your lordship, in court number 5. He'll
for the
include
timing?
Much obliged.
Pass over for the time.
Item 22.
Common land.
Yes.
Please, your lordship, we'll be filing our wakalatnamas today, your lordship, for the respondent number 711, and there's 20 other respondents, your lordship.
Lordship, the appellant side was supposed to file affidavit, they have not filed the affidavit.
Appellant.
Appellants, I am from the respondent side.
Lordship, there are 150 numbers of petitioners, your lordship. They are appearing for 13, will be appearing for 7, 11, 12, 13, and others. There are many.
No, Union
Service
of
of-
India, you are appearing from the Union of India.
No, your lordship, I'll be appearing for private respondents. Service of notice was not completed.
Private.
Lordship, there are 150, Lordship, there are 150 respondents. Lordship, there are 153 respondents. We are appearing for some of the respondents. It is mentioned in the.
Ultimately, it is for the admission. Whatever it may be, service. Service is not the issue. You are appearing for the respondents.
Yes, your lordship.
Private respondents.
Not all respondents,
Some of the.
some of the respondents.
And you are appearing,
Respondent, I have to see that.
you
Is
are
it-
also appearing from some of the.
Some of the, it is reflected in the cause list.
Who is appearing for the appellant?
Appellant,
Is Gupta
is to appear. H. Gupta was supposed to appear today. They were supposed to file an affidavit.
So how you are entitled for this compensation?
Lordship,
The private respondents, how we are entitled for the compensation? In lieu of the government lands. You
Lordship,
don't have any
Lordship-
title over the land.
Lordship, we were sitting on the land since 1970 to
Whatever it may be, ultimately you must have some title. It's a government land. You are simply encroachers.
Lordship, we are not encroachers. We are shown as realties, and it was we are sitting in the land since 1970 to 71. In fact, the
Whatever
DC has
you
submitted that
You may.
we are shown as the
You
realities,
may
Lordship.
possession of the land since immortal times, but ultimately what is the right? Your right. Ultimately, the land is government land.
Lordship, the state government also has not also opposed that we are not
The state
encroachers.
government, the state government may not oppose, but how you are entitled for them? Yours.
Lordship, we have filed an affidavit. Can I read?
My lord,
Can
the
I read?
affidavit. No, the affidavit was filed, my lord, during the last working day of the vacation. We will file reply to it, my lord.
What is the, where is the need of filing a reply to that?
Certain new facts have been stated, my lord.
Mr. Gupta, please go and granted further 10 days time to counter to the affidavit filed on behalf of some of the private respondents. Just after 2 weeks.
Lordship. There are certain respondents who have expired, your lordship. Passed away, lordship. Certain.
Supply the information, they'll
Will give it.
bring the legal representatives of the on the court, supply the information.
Item 23,
Reply not filed, my lord, in terms of order 29.
Lordship, we need some time, Lordship, to obtain instructions.
Why, what? Obtain instructions you are appearing.
Some development is going on, Lordship.
Appearing for. You're appearing for whom?
2 and 3, Lordship.
Respondent number 2 and 3, there's some more time to file the response. In this, file a response in this, writ appeal.
My lord, my submission of my learned friend may kindly be recorded, my lord.
Yeah,
My learned friend has submitted some development in
what development?
that.
What development is
That may
going on?
kindly be recorded.
Development is going on that they are for instructions and they are not providing those instructions. These are the development and nothing else.
May I pray for fixing of a date, ma'am?
Then 4 weeks के बाद की date.
I am obliged.
Response for, yes.
29 November.
I am obliged.
Item 24,
This matter is fixed for consideration of the interim. Court.
Lordship, may I pray that this matter be taken up on 11th? Lordship, I have received the instructions. Let me file my affidavit.
On 11.
11th.
Okay, Mr. RKT Chaudhary. Raise some more time to file. Response to the petition. He pray, he says that it may be listed on 11th of 2024, list of 11th of November 2024 for admission. The prayer for interim leave shall be considered on the next date.
Right.
supplementary list for orders item 58.
No, sir.
Here on last occasion, Lordship is to suppose, madam. May I pray some time to file a short reply, madam?
You have already, were granted,
We have filed our affidavit. After, true, madam, we have filed our affidavit here.
you have already filed?
Filed, no.
No,
When you have filed?
after 23/9.
After 29, we have not filed.
Why?
And after your lordship's last order, the petitioners were summoned to the office at Dispur. They were rebuked and said that we'll take course of action against you for filing this contempt petition. We have not brought it on record, but let's take contact. And there's,
Well, a short time maybe granted, we will file a short affidavit.
I think, my lord, your lordship has to direct for a personal appearance.
Okay, who are the, you are supposed to file counter on behalf of whom?
Respondent number one,
On behalf of
madam.
whom?
Respondent number one, madam.
Respondent number one. Okay, we will grant you the time subject to the condition, and on the next date, if you will not file, then you are going to,
It is a personal appearance.
what is this, what course you ordered for?
Well, that, we are trying to bring it on record by filing an,
Do you have any?
if your lordship gives me 5 minutes, I'll bring it. 5 minutes, madam.
5 minutes.
Yeah, I think it's on fifth. I have the copy. It's now being photostat for bringing it on record by filing an application, because during the course of the day only, it will be brought on record, but.
Well, a short time maybe granted, madam, we will file our reply. Short reply.
Mail to someone,
I as
mail to more, laptop to this one. Oh, laptop. Laptop, I need the other copy to laptop. I have it in me. No, I don't know. The Muslim. Muslim. Muslim upon.
Oh, yes. Yeah.
On 23/9/2024. This court has expressed its prima facie opinion that the respondents are guilty of willful disobedience of the orders and directions passed by this court. Well, after observing these notices were issued to the respondents that the respondent to show cause why they should not be punished for committing the contempt of this court. It's further observed that response on behalf of the respondent be filed by the next date of hearing if they desire so. Till this date, no response has been filed on behalf of the respondents.
One and
Respondent number 1 and 2. Who are supposed to comply with the order passed by this court. It's for Lanet counsel appearing for the respondent number 1 and 2.
Yes.
Has submitted that one more opportunity be granted to file response in view of the notices issued by this court. By the order dated 23/9/2024. In the interest of justice, last opportunity is granted to the respondent number 1 and 2 to file their response. Failing which the respondent number 1 and 2 shall remain present before this court personally. Based on
After a week, Mel.
date, you have to appear.
Can it be on sixth, Mel?
6th of November, as prayed by the learned counsel for the respondent.
I have given the order after your lordship last order. They were summoned by this order of 310 to appear on court before the joint secretary. When they appeared, they were treated, rebuked, but that you have filed a contempt petition, we may give you, but we'll take action. You will be working under you. So we have brought this where and more. That's why we have tried to bring it
So
up.
the, will comply with the order
Yes.
and what they, how they have threatened.
I said that you are filing a contempt petition. You are working as a tutor. You think that High Court will protect you all the time. It's better we bring all this statement on the record, but because and they are saying that since only 2 petitioners have filed this contempt petition, because the others are not there, so we'll not give them the benefit. Don't worry. That's why the other petitioners also came and appeared. They are also filing a separate application for interview.
Bring it on.
Yes, madam. We are filing it during the course of this day only.
Bring it on.
Yes, madam.
Obliged, Mel.
Item 39.
Yeah.
Lordship, I am appearing on behalf of petitioner in person, Mr. S. Samaria. Lordship, we filed this IL Lordship as per the direction of this honorable court.
Will grant it. Matter comes upon for consideration of the IA number so and so with the prayer to include the Director Official Language Implementation Assam as party respondent number 6 in the PIL petition number 23/2024. So
I may accept notice.
this court might order the 11/9/2024 as ordered for including the Director of Official Language Implementation Assam as party respondent. In view of the above, IA is allowed. The Director Official Language Implementation Assam is implemented as party respondent number 6. Amended cost type will be filed within a period of. Have you filed the amended cost type?
No, Lord.
Amended cost type will be filed within a period of 10 days. Registry is directed to make necessary correction in the CIS portal.
Item 40.
Well, the matter may pass over the time being, my lord. Senior counsel, my lord, court number, another court number. Time being, my lord.
Okay, for the time. Password matters.
Passover meter, item 1.
This matter, my lord, they are simply adopting the delaying tactics. You'll also see that this is a matter of 2012. The Honorable Division Bench at Shillong has also confirmed the order of the Central Administrative Tribunal. So nothing remains. I don't know, you'll also said in the last order that they may approach the Shillong Meghalaya High Court. But I think there is already a division bench order of the Meghalaya High Court affirming this order. So, but I have given the sequence of the
May I submit,
the
Lordship?
facts.
Yeah, when we came to know about this order of the CAT, then we had filed a review before the CAT. So we are challenging before this honorable court, the review order, which because we were not made a party in that original application before the CAT. So accordingly, we have filed a review. Once we came to know, we filed a review.
The CAT order has been affirmed by the division, by the Meghalaya High Court.
Yes.
Yes, Lordship, that we came to know later on. May I submit on that part?
You may You may, this fact may come into knowledge later on, but ultimately, once the division bench of the High Court
Yes, Lordship.
of Meghalaya High Court has already affirmed the order which you sought to be reviewed before then the proper course for you to approach the Meghalaya High Court.
But one
You can't
sentence.
sit as an appellate authority.
No, I understood. May I submit? Because on that quantum of the proportionate share, because mother has challenge of the deceased, mother of the deceased, who is the grandmother of the petitioner herein. Sorry, Lordship.
Have noted all these things. In
Yes.
The order dated 20th of September 2024.
Yes, Lordship.
So how this writ is maintainable here, ma'am?
Then Lordship, if that be so, then I would like to have the liberty of this court because there is a delay, Lordship.
Granted you.
The delay has been quite some time and now we have to get the.
For that I court to consider.
But Lordship, in that count, Lordship, I'll humbly pray that because since we approach, because once we came to know about the order.
Raise this plea before the Meghalaya High Court, they'll consider it.
Lordship, on that count, Lordship. Because it's.
Who can be observed this?
That may be there in the order of this honorable court. Observation that we had filed a review.
Ma'am, this order 23/9/2024, do you have the 20th of September 2024? Do you have the copy of this order?
I'll just check right.
At page 71 is the order of the Meghalaya High Court. And my lord, to make, sorry.
Yes,
sir.
Please.
71 of us moved it.
Itu order ko ta kona 30 of this honorable court.
Ms. Ghosh, have this.
Got a mistake. You don't.
We have already observed now.
Yes, Lordship.
Taking into above facts and circumstances, we are of the view that the writ petition filed by the challenging so and so passed by the is not maintainable before this court, and the petitioner can challenge the impugned order by filing writ petition before the Meghalaya High Court. That we have already ordered.
Yes, Lordship.
Then
Yes, Lordship, then this
we are
will.
attempting to argue the matter for quite some time, but the concept of the petitioner has submitted that the concept of the petitioner on the instruction has submitted that the petitioner be allowed to permitted to withdraw this petition. However, with liberty to approach the Meghalaya High Court by initiating appropriate proceedings. Stop. Dismiss with liberty, dismiss as withdrawn with liberty as paid for.
Yes.
You are blessed, sir.
Item 19 and 20.
The amendment has been notified and gazetted, my lord.
Notified and gazetted. Now what we need.
No, that is not the issue, my lord, here, but
That is the issue, sir.
Ascend copy, yes.
ADC. Serial number 3, man. In the amendment rule, the term used was appointment. We have converted to promotion for the orders of the honoraries. The others are separate amendments. Serial number 3 relates to this particular rule.
5% you
The grievance was that we had used the word appointment, shall be made by appointment. So now we have changed it to promotion as required by the earlier division bench order and the orders of the learned single judge.
Exactly, my lord, my grievance was, my lord. My lord, all these, my lord, appellants before lordship, they were appointed, my lord, while the 2003 rules were there. The education qualification was HSLC. There was no promotion avenue. So the
in the rules of 2018 or in the earlier rules?
in the 2003 lordship. So they had approached this honorable court. And this honorable court having found that they have a genuine grievance, a direction had been issued to them, my lord, to take the note of the grievance and accordingly make a suitable provisions for promotion of the my lord, these employees who do not have a my lord, avenue for promotion. Now, my lord, 2018 rules have come. So far as junior assistant is concerned, they have prescribed the qualification as graduate. And so far as my lord, grade 4 employees is concerned, that remain to be HSLC. Now, in the 2018 rules, there was no my lord, promotional avenue even from the grade 4. They have come up with a notification saying that the direct recruitment will be done from this my lord, eligible my lord, grade 4 employees who is having the requisite qualification for the post of junior assistant, that is graduation. And admittedly, these persons do not have the my lord, qualification of HSLC.
So what's wrong in that, sir?
My lord will kindly find in
The state government is very well competent to prescribe the criteria for promotion by mentioning the requisite qualification.
my lord, while my lord, the petitioners were appointed, their qualification was my lord, matriculation, and for the junior my lord, assistant was my lord, HSLC. No, my lord, the High Court in the earlier round of writ petition has directed to take a realistic approach. Now,
Realistic approach, that is the realistic approach. Now, if they come with this, only those persons who are having this qualification will be promoted on the post of junior assistant. What's wrong in that? That is within the domain of the government.
My lord, that
can't be
my lord, that will my lord, my submission is that will infringe the my lord, Article 16. My lord, they are trying to make a my lord, as well as my lord, 14.
You'll find
Lord, first of all,
empty number of judgments on this.
my lord, the earlier judgment of the High Court was for the employees, those who are appointed my lord, under the
We are talking about Supreme Court judgments, sir.
lordship, my lord.
In fact, in the earlier judgment of this honorable court, the division bench judgment we required to bring other amendment. It specifically says suitable provision for promotion of class 4 employees to the post of junior assistant by prescribing such eligibility criteria as it may deem appropriate. It was in the mind of the honorable court.
No, my lord, the realistic approach, what would be the realistic approach? My lord, as good as well, this promotion avenue that has been made, as good as it is denied to all the employees who were appointed under 2003, because the quality.
If any person who was appointed under the 2003 and later on acquired, or at the time of his appointment having graduation qualification, is eligible for promotion as per this amendment.
My lord, here they have said for the my lord, qualification would be required for the junior assistant post, not with the existing qualification.
That is enough. It cannot challenge them.
In fact, before the learned single judge, the office memorandum was under challenge. Now, since the rule has been amended, a writ appeal would not suffice to challenge the provisions of that rule.
I am challenging that, honorable single judge, judgment on this ground that although, this notification has been issued, it has supplanted the
Sorry, page. Given a period of judgment because subject to amendment. When he challenge and case and make confusion. Two, learn into the children. And the office memorandum was kept in fact. If they against me, then in persons to the directions, now they have. Right, amending it. Schedule by. Schedule means junior assistant picking up.
Now, if you are aggrieved by this rule, challenge this rule. Once they have amended the rule, office memorandum goes. Now challenge the rule and the schedule. That is there. But then this appeal was filed prior to this amendment coming into force. In between, if the amendment has come into force and you are aggrieved by it, challenge the amendment. Lordship will grant me the liberty to challenge it.
In fact, for other ministerial services at district level, in 2015, it has been made graduation for grade 3. There are other rules also.
My whole contention, let them challenge. This. Right. Petitioners. order dated challenging the order dated 24/6/2022 passed by the learned single judge in writ petition number 3283 of the 2022 and two other cases. The petitioners have also challenged the office memorandum dated 28/9/2029, that's 21, issued by the Special Commissioner Secondary Education Department. Full stop. During the pendency of the writ petition, writ appeal, the state government has amended Rule 5 of the Assam Secondary Education in brackets Provincialized School Service Rules 2018, making a provision that 5% of the total post of junior assistant of a district shall be filled by promotion from grade 4 employees of the school under the concerned district having 5 years continuous service as a regular grade 4 employee and having requisite qualification applicable to the post of junior assistants as mentioned in sub-rule 3 of rules of 2018. Stop. And it concept of the petitioner has submitted that since the rule 5 of the rules of 2018 has been amended by notification dated 7th of October 2024, the petitioners, the appellant wants to withdraw this writ appeal, this liberty to challenge the amendment in the rule 5 by initiating appropriate proceedings. Dismissed with liberty as prayed for.
Publish.
Publish.
Two written.
Two written, same order.
Two written.
Okay, let's say,
We are the amendment.
19 not survive.
Yes, the amendment favors us.
You favor, okay. Lanet, इसमें 19 में लिख देना. ये तो आ जाएगा रेट अपील नंबर 332/2022 19 में लिख देना. Concept for the petitioner has submitted that with the amendment in the rule 5 of the rules of 2018 पूरा लिख देना. 18, the grievance raised by the appellants in this writ appeal has already been redressed, and therefore this petition, this writ appeal has become infectious. Dismissed as infectious.
Pass over meter 40.
May it please your lordship. Now, if the lordship will kindly come to the NIT meter at page number 551.
So Chaudhary, on last occasion and today also Mr. Indranil Chaudhary has said that the contract has already been awarded.
Bilal?
Contract has already been awarded.
Yes.
You are aware of that?
In fact, this is the written instruction that we have.
After passing of this order by the learned single judge, contract has already been awarded.
Oh, my lord, if the learned single judge's judgment is interfered with by your lordship.
Rights.
See, they have already.
No, my lord, I think there are further steps to be gone into. In
Only time is
any
given.
case, my lord, the existing contract with the petitioners are up to December. So, my lord, this award of contract is not going to nullify my thing. Cause of action, otherwise, if we have merit,
At
it
least they
survives.
now have to make them a party.
Anyway, my lord, we are at this, if your lordship interferes with the order of learned single judge, the consequences will follow. If we succeed in persuading your lordships. Yes, yes. My lord will kindly come to page number 551. I'm sorry, Milord. I'm sorry, Milord. Lordship will kindly come to page 110. Is the tender impugned tender? Lordship may straightway come to page 113. Kindly see, Milord, tender description at page 113.
Just, yes. One, 1, 3.
Yes, Milord. It starts as 1110. The second column, tender description, hiring of services of brand new 317 number of light vehicles, taxi for Assam asset for a period of 4 years on lottery basis.
This,
Now,
this
second one, Milord.
second tender description.
Yes.
Yeah.
Hiring of service of brand new 372 number of light vehicles for Assam asset for the period of 4 years on lottery basis. Now there are 6 categories. Category 1, 278 numbers, Mahindra and Mahindra Bolero, so and so. So my lord, these are the different categories. In all, it is 372. Then my lord will kindly come to the next page. Kindly come to the third one, my lord, draw of lots. Against the current requirement of 372 vehicles under the tender, a total of 500 applicants will be selected by the first round of draw of lot, that is shortlisted applicants. The first 372 could be ranked as the shortlisted applicants, and rest, that is 373 to 500, subsequently ranked as waitlisted applicant category wise. So basically they will draw based on draw of lot. They'll prepare a list of 372. From 372 to 3 to 500, that will be waitlisted. Now I am on this, my lord, methodology of award. Normally a tender, my lord, contains a technical bid and a financial bid. Here there is none. The learned single judge, my lord, admits to a large extent. But in spite of that, my lord, learned single judge did not interfere. The application submitted by the applicant will only be eligible for those categories of vehicle selected by the applicant while submitting their application. Contracts will be awarded to the applicant selected through draw of lots, subject to availability of those category-wise vehicle at the time of draw of lots, which have been selected by the applicant while submitting their application, are also subject to fulfilling all conditions as stated in para 3.0 and 4.0 of this tender. So, my lord, only methodology is draw of lots. Now, my lord will kindly come to the next page. As far as rates are concerned, this is also prefixed. For example, my lord, applicable rates for category 1, Mahindra, standard charges per day 4341, etc., etc.
You are not agreed by the, you are simply agreed by the methodology of
Yes.
the award.
Yes.
The draw of lots is not fair. Or
Yes.
can be treated-
Not only fair, normally it can't be construed in the meaning of a competitive bidding. Draw of lot is something else. Now, if your lordships will kindly come to page 118, clause 2.2. log in to the application system, and after verification of the registered email ID and mobile number, the applicant shall enter the following details. So Lord may kindly skip over to 119. Basically, my lord, employment exchange number, PAN card, mobile number, etc. And there's one stipulation, applicants falling under 18 to 55 years on the tender closing date will only be allowed to participate in the tender. Then my lord will kindly come to page 120. This is confined to 4 districts of Assam only. Others cannot participate. Page areas. Page 120. Application from individuals having valid employment exchange card from employment exchange of any following areas shall only be accepted. So the applications from others can't even participate. Then my lord will kindly come to. This? No, not. I'm just pointing out, my lord, how mechanically things have been done. Now, page 176. Clause 13 of the special terms and conditions. Light vehicles have been classified into 2 different categories, self-driven and ownership. Self-driven light vehicles shall be driven by owner himself throughout the contract period. Owner has to give written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated with immediate effect. Ownership. Light vehicle have been awarded to contractor. Contractor may hire another driver for driving the vehicle. So these are basically the my lord tender conditions. Now I'm relying on one judgment of the Supreme Court, my lord, where Supreme Court has said what would constitute a tender. Objection. 2012 8 SCC 216 Michigan rubber, my lord. 2012 8 SCC 216.
Yes.
Now please come to page 229, my lord, para 23. I'll read, my lord, A and D.
Yeah.
The basic requirement of Article 14 is fairness in action by the state, and non-arbitrariness in essence and substance is the heartbeat of the fair play. These actions are amenable to the judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it will be legitimate to take into consideration the national priority. D. Certain preconditions or qualifications for tenders have to be laid down to ensure that the contractor has the capacity and resources to successfully execute the work. I am on this clause, my lord. The tender per se must lay down certain precondition of qualification so that one can demonstrate that he has the capacity. Here you have seen, my lord, even unemployed youths of below 18 years of age, housewives, everybody got it, my lord. How they're going to run it?
Below 18 years.
Yes.
If it is so, then it has to be terminated.
No, I'm coming. We have, my lord, filed an RTI applications which they have not, answered till then. Now, my lord will kindly come to, my lord, according to us, college-going student, women below poverty line, person having no work to place vehicles have been done. My lord will kindly appreciate one thing, my lord. Before this tender, earlier there were different practices was followed. Eventually, they came up with a policy of 1 vehicle, 1 applicant. That was challenged in the earlier round of litigation, which has been rejected. So now there is no difficulty. Question is, my lord, idea was to address the problem of unemployment. That is why this was done, because the district administration was also involved. But if a process leads to, my lord, further chaos in the system, I don't think it is in public interest. Now kindly come to the, my lord, the learned single judge's observation at page number it starts at page 51, my lord. And I'll have your lordship's kind attention to page number 65, para 23. If this observation satisfies your lordship, perhaps I have no case, but then I think it's a case where your lordship would like to examine it. Para 23 at page 65. It is correct, as argued by Sri So-and-so, that certain preconditions or qualification for tenders have to be laid down to ensure that contractor has the capacity and resources to successfully execute the work. At the same time, in the considered opinion of this court, in the case in hand, such conditions are already prescribed. The precondition qualification and capacity is measured under the tender in question by imposing precondition of having a new vehicle with BS4 standard and the driver having a valid license. And this is the requirement. This is not the way to measure somebody's, my lord, capacity. This is the product or the, vehicle which they want. How can that by itself be a, my lord, criteria to judge whether one has the capacity? Well, what I mean by supposing whether a person is in such business, whether he has executed similar work, that's normally the condition. Yes. With all respect, my lord, I don't think. What I mean to say is, my lord, no, my lord, what I mean to say is, then, my lord, this CBC's guidelines would makes no sense. If that is a view to be taken, my lord, there may be 1,000 people in Sibsagar town. No, my lord, there may be 1,000 people in Sibsagar town who has one new vehicle. Does it mean, my lord, that by itself would be enough? Is it not required whether in the past he has done some similar business, whether he has financial capacity? My lord, it could so happen a big time people may be behind the screen. No, my lord. My lord, no, my lord. No, my lord, that is required. Everywhere, my lord, in a job also, when one person applies for a job, no puede, se puede. Ya no. My lord, in the earlier round of litigation, ONGC filed an affidavit. I'll place that paragraph, my lord, what they said and what they did. Please come to me, lord, page 538. Para 11 of the affidavit filed by the ONGC in the earlier round of litigation. Page 538. Para 11. That with regard to the statement made in paragraph 10 and 11 of the writ petition, the answering deponent denies the statement therein and further begs to state that petitioner has wrongly stated that Kaveri asset so-and-so is situated in the state of Gujarat as the same is located within the Union Territory of Puducherry, which itself reflects the lackadaisical approach of the petitioner in making the baseless allegation against the ONGC and harming the tender process. Further, the answering deponent could not process the tender owing to receipt of several representation and onward meetings with the Deputy Commissioner. Now, this is important. And therefore, to resolve the prevailing situation, the higher management of ONGC decided to adopt the model of oil Duliajan Assam, which is operating successfully, specifically for hiring of light vehicles in Assam asset. It is also pertinent to mention herein that idea behind adopting the model of oil Duliajan Assam is to simplify the process of tender for light vehicle in Assam, which has presently been troublesome in Assam asset, and also the model has been successfully running in Duliajan Assam only. So they said on oath, my lord, that they will adopt the oil model. Now let us see the oil tender, my lord. Oil tender is at 551. .551 is the tender, and relevant pages, my lord, will kindly come to 562, 566, sorry. 566. .2, my lord. Bid security. Then my lord will kindly come to page 572. .8.1. Technical bid comprise of the following: containing certificate of compliance in respect of BRC of bid document, complete technical detail of the service and equipment specification, documentary evidence established in accordance with clause 9.0, statement of non-compliance, etc., etc. 8.2, commercial price bid comprising following: bidder shall quote their price in the following pro forma and shall upload the same in oil portal. So price bid as per relevant format, price bid. So my lord, the oil model which they adopted, my lord, that itself provided for a competitive bidding, unlike the draft law which they have adopted here. Now kindly see page 73. No, my lord. No, my lord, this is the tender issued by Oil India Limited, which in the earlier affidavit ONGC has stated that they are going to follow. Huh? Huh? One vehicle. And through, no, whether it is 1 or 100, my lord, criteria is same. Through draft lot, but my lord, this was the eligibility criteria which was specified. Kindly come to page 573, 12. Documents establishing bidders' eligibility and qualification. These are listed in part 2 of the document. Then my lord will kindly come to 576. My lord. Yes, part 2 the page. 1 second, my lord. Part 2 starts at page number. I'm coming, my lord. Part 2. 1 second, my lord. Part 2 starts at page number 593, my lord. Bid evaluation criteria, bid rejection criteria. Now kindly come to page 2.1, 594, technical evaluation criteria. Page 594, 2.1. A relevant experience of having successfully completed one similar work of the value of rupees 8,20,800 with central government, PSU, state government, etc. In the last 7 years to be reckoned from the date of bidding. Similar work mentioned above means bidder shall have the experience of providing service of hired vehicle, etc., etc. So normally these are the conditions, my lord, in any tender we find. Page 550. They do the challenge. Read petition of 19. Hey, read petition of 19. So, my lord, my humble submission is very simple. We are also transport operators, my lord. Yes, presently we are undertaking the contract. Our contract is valid up to 31st of December. Not necessarily one vehicle. One or two vehicles. Only one vehicle. No, or presently also only one car, my lord. This per petitioner, they have given only one car. My lord, my point is very simple. Based on the Supreme Court judgment, subject to what your lordships may say, my understanding is, my lord, in order to constitute a tender, there must be some element of competition. Now, lords will have to give some meaning. Now, the learned single judge has taken the view that by they themselves say that they will follow the oil model. Yes, D, my lord. Yes, yes, D basically. Yes. C, my lord. In the matter of formulating conditions of an, no, yes, while formulating the my lord eligibility criteria. My lord, I'm making one very responsible statement based on the instruction, my lord. We have come to know women below poverty line, students, they have also got in the lottery because nothing was to be shown, my lord. Only by picking up that piece of paper, that will do. Now, my lord, some people are behind them. There is nothing to verify those. My lord, we have applied under RTI. That application is annexed, na? We have annexed that application, my lord, but it is not forthcoming. My lord, I want an answer only on one point, my lord. Whether by draw of lots, without specifying any eligibility criteria or financial criteria, can it be construed as a tender? Because end of the day, my lord, tender involves some element of competition. In that case, are we not leaving it to the mercy of the authority, my lord? We never know what is happening, my lord. Only picking up a piece of paper, is that enough? And the learned single judge's view that by prescribing the model, technical specification has been prescribed is not correct, my lord. So that is my submission, my lord. I will not elaborate. My only point is this is not a tender. It cannot be construed as a tender. It is simply a draw of lot. It is bereft of any attributes of a tender. Therefore, my lord, relying on Michigan rubber, yes, when it comes to, detailing the technical condition, there they have the liberty. There they have the prerogative. But they must first lay down those. Whether they would say we require experience for 1 year or 7 years, that is their prerogative. But some experience must be prescribed. But that is my submission. Because the criteria, yes, that have been consistently held by the Supreme Court, that employer is the base judge to lay down the conditions. But as to what would be the conditions, that we are not questioning. We are questioning there is no condition to determine the eligibility.
As your lordships have noted, the tender pertains to hiring of taxis of different makes and models. Now, the only two requirements that we as an organization would have is a vehicle in a good condition and a driver who has a valid driving license, commercial driving license, and some amount of experience. Now, earlier what had happened was on account of certain conditions, tender conditions, one small group used to monopolize the entire, all the contracts. There was a large scale resentment in the locality. Ultimately, the district administration got involved and there was a tripartite meeting. If your lordship will kindly come to page 310. Various stakeholders had submitted multiple representations. And the district administration got involved. There was a tripartite meeting between our officers, the stakeholders, and the district administration. That minutes your lordship will find at page 310. All were, it was open to all. That specific instruction, they have. There, I'll come to who the petitioners are a little later. Page 310, your lordship will find there was this tripartite meeting held on 8th of August 2023. And if your lordship kindly turns the page to page 311, your lordship will find what was the decisions taken. After threadbare discussion on all the issues, it was decided that tender for single vehicle will be accepted for single individual through lottery. Experience certificates, etc. We are not really concerned with that. The last paragraph, your lordship will kindly note. Further, the district commissioner requested the ONGCL authority to review the matter at their level and come out with a rational solution that genuine demand of unemployment may be addressed. Now, based on this, our officers at the highest level, they looked into the entire policy pertaining to hiring of vehicles and they modified the policy, which your lordship will find at 312. Our very manual of procurement underwent a review. There was a review of the policy itself. This is dated 19/9/23, which your lordship will find at the top right-hand corner at 312. This is dated 19/9/23. EPC in its meeting so-and-so held on 7/9/23 reviewed the evaluation of tenders for hiring of light vehicles in Assam and decided hiring of light passenger vehicles on one applicant, one vehicle basis at the rate offered by ONGC using draw of lots. As per decision taken by EPC, provisions of integrated manual have been modified in respect to evaluation of tenders for hiring of vehicles in Assam as per attached annexure 1. This annexure 1, your lordship will find at the next page. And it reiterates basically that it will be one applicant, one vehicle, and the selection will be done through draw of lots. The reason is very simple. My learned senior colleague is right in saying that we consulted Oil India Limited because it has been also hiring consistently vehicles. And they have been resorting to this same model, one applicant, one vehicle, and through draw of lots. Now, Oil India's experience says that thousands and thousands of applicants come. So therefore, when the rate is fixed, yes, the rate is fixed. The basic experience criteria, I'll come to that. That is fixed. So everything remaining constant, how do we select? All are equal. And there are thousands of applicants. So naturally, draw of lots is the only fair selection criteria. And like Oil India, what we are doing is to maintain transparency. We are in our website. It is readily, even today, one can go and examine how the draw of lots is taking place. All stakeholders are present. People from the district administration are present. And in presence of everyone, it is now published in the website, the video recordings. And it is available live, even when it is going on. Now, coming to the tender itself, if your lordship will kindly come to the NIT at page 110. As I said, our requirement is a vehicle in good condition. So what do we say if your lordship comes to page 113? In that chart, your lordship will find towards the middle, your lordship will find make and model of the vehicles. And your lordship will find the requirement, what we require, we have specified. Brand new vehicles with BS6 emission norms. So it should be a brand new vehicle and it should comply with the BS6 emission norms. Now, if your lordship will kindly turn to page 174. my learned senior colleague is again right in saying that some experience has to be there, and we have prescribed. Scope of work, technical specifications and special terms and conditions, etc. Page 174. In that, the 6th paragraph, your lordship will carry. Under the scope of contract, permanent drivers in possession of valid commercial license are to be provided to avoid any disruption of ONGC works, shall maintain the vehicles in absolute working condition, shall ensure that the drivers are disciplined, smart in turnout, well dressed in uniform, having minimum 3 years driving experience in hills and plains. So therefore, what we require, we have prescribed. The rest, what they're trying to say is trying to impose what would suit them, whether that is permissible. Now your lordship will kindly, if your lordship sees the cause diagram, very interesting, your lordship will find who is the appellant number 1 and who are the rest of the appellant. There is a reason for why I'm making this submission. The appellant number 1 is one self-dependent motor driver union, and 2 to 13 are individual. The reason is very simple. They do not have an authorization. The appellant number 1 does not have the authorization by the union to file, because if your lordship sees the members list at 104, there are a total of 93 members. We do not even know whether all are really agreed. We have raised this objection before the learned single judge on affidavit that they do not have the authorization. And assuming all 93 are agreed, as opposed to that, your lordship may just make a note of this number. As opposed to these 93 people, we received 28,076 tenders. To draw blocks. That is why, because the only fair manner would have been, because these are fixed. Everyone is, the rates are fixed, the make and models are fixed, the experience, minimum experience we have given 3 years. So how do we fairly decide whom to award the contract? Any other method would be arbitrary. So therefore, and draw of lots is not alien. Your lordships are aware under section 102 of the Representation of People Act. If there is a tie in votes, it is decided through draw of lots. When all things are constant.
In the election of a comparison.
No. That is why I was emphasizing that when everything else is constant, the fairest method to select, what would be the fairest method to select? Yes, the challenge was appeal file, no interim order. The writ appeal has been recently withdrawn last week. Now, the oil model that was writ appeal, I have the copy of the order.
Uh,
93 one. They have annexed the members list.
93, my lord. No, my lord, the union, there is a resolution, my lord. Perhaps my learned friend has not gone through the petition. Please come to page 45, my lord. My lord, we have just come, but the association had the authorization and we have mentioned also, my lord. Yes, yes. The last 6-7 lines, my lord, at page 45 of paragraph Q. The appellants, to avoid bulkiness of the writ petition and to prevent the available time, and have not submitted each and every document with less relevancy to the issue, although the appellants are armed with all those required documents, including resolution of the members. More so, in the connected affidavit and writ petition, it has been categorically stated that union has duly authorized the appellant to file the writ petition. And we are holding the resolution also. And my lord, the registration is at page 103. As a trade union. 103.
It's a register.
Registered trade union, my lord.
I was pointing out the oil tender. The oil tender that was placed by my learned friend pertains to, as has rightly fallen from Honorable Chief Justice. That pertained to only one Scorpio vehicle. The other oil tender is annexed at page 327. Where several vehicles were tendered for. The Lordship 327, it starts, Oil India Limited. Your Lordship will kindly turn to the next page, page 328. Number of in that chart, your Lordship will find at the bottom number of vehicles required. The requirement of vehicles will be declared before draw of lots based on company's requirement. The application submitted by the applicants will be eligible for both the categories of vehicles. The contracts will be awarded to the successful applicants from draw of lots as per priority list of both the category of vehicles from the single draw of lots. Now, if your Lordship kindly turns to 331. At 3.0, brief selection procedure for award of contract. B and C will reflect that the entire selection is based on draw of lots. The logic is very simple, my lord. If all things are constant, the fairest way would be, fairest and impartial way would be through a draw of lots. And similarly, Oil India also gets thousands of tenders, and it is decided they also have a video recording and stream it live. And we also do the same thing. But therefore, my lord, in my respectful submission, there is absolutely, and the Honorable Single Judge has gone into all these aspects.
Just 5 minutes reply, my lord. Now, my lord, the oil's affidavit, tender at page 333, 327, my lord. This is January. It was prior to that tripartite meeting. Now, my lord, my learned friend has not shown one thing to your lordships. He should have actually. Please come to my lord, page number 315. 315. My lord, kindly see the note. The same, following the my lord minutes, this is what was recorded. Note. Assam Asset Cell Frame BEC bid evaluation criteria. Detailed letter tender clauses in consultation with Oil India Limited, and same shall be approved by concerned L1 executive. Other work centers in Northeastern may adopt BEC tender clauses finalized by Assam Asset.
Yes, we have. We have done so. We have done it in consultation with Oil India. This is not a pleaded case that we have not consulted. If that is the case, we can put it on record by filing an appeal.
I am not on that, Milad. I am on this. Assam asset will frame BEC, bid evaluation criteria. Where is that bid evaluation criteria? My lord, you are prescribing you want X vehicle. That is not bid evaluation criteria. And they will do in consultation with oil. Oil has done it.
Why wasn't oil made a party in that case? If the entire case is based on oil.
Their affidavit says that they will follow oil model, and now I need to implement Oil India Limited. I'm not seeking any relief from Oil India. That is a elementary knowledge, my lord. Nobody has to bring in everybody, each and everybody. But here is a case where they are, my lord, trying to set in chaos in the entire system. You profess something, you did something. My lord, can by any legal reckoning, it can be said by prescribing the vehicle which is required to itself is, my lord, that it is all inclusive. They say they need X vehicle. How can we say, my lord, that is constitutes, my lord, a technical criteria? They themselves say Assam asset shall frame BEC. BEC stands for bid evaluation criteria. If my learned friend can show any bid evaluation criteria, is well and good.
There's just one thing I overlooked, my lord. There's one judgment, recent judgment. That is, it is 2022 SCC online, SC 1967. Your lordship may just have a look at para 9. I'm relying on para 9.
Tata Cellular judgment election. 1994 6 SCC. Well, two small paragraphs from Tata Cellular, 69 and 70. Okay. My lord will kindly come to page 675. Yes. Tender is an offer. It is something which invites and is communicated to notify acceptance. Broadly stated, the following are the requisites of a valid tender. It must be unconditional, must be made at proper place, must conform to the terms of the obligation, must be made at the proper time, must be made in proper form. Person by whom tender is made must be able and willing to perform his obligation. There must be a reasonable opportunity for inspection. Tender must be made to the proper person and it must be a full amount. It cannot be denied that principle of judicial review would apply to exercise of contractual power by the government bodies in order to prevent arbitrariness or favoritism. However, it must be clearly stated that there are inherent limitations in exercise of that power of judicial review. Government is the guardian of the finances of the state. It is expected to protect the financial interests of the state. The right to refuse the lowest or any other tender is always available with the government. Now, this is important. But the principles laid down in Article 14 of the Constitution have to be kept in view while accepting or refusing tender. There can be no question of infringement of Article 14 if government tries to get the best person or the best quotation. The right to choose cannot be considered to be arbitrary power, of course. The said power is exercised for any collateral purpose. The exercise of that power will be struck down. And at the very basic fundamental, to get the best tender, to get the best offer, unless there are conditions prescribed, my lord, how do we get that? My lord, it all depends upon the facts of each case. Now, Article 14 has to be given, my lord, quad the draw of lot which is sought to be imposed, my lord. Otherwise, why Supreme Court has said, my lord, that there has to be some eligibility criteria. Otherwise, how do we judge Then my lord, draft lot is in a different realm altogether. In the name, to achieve the purpose of a tender, is it permissible to resort to draft lot, my lord? Tender is a method by which, my lord, the best services can be availed. Now, how can that be bypassed? I am on that, my lord. In the given facts of the case, whether that is permissible, that is an aspect which I humbly pray Lordship will consider in the facts of this case. And more so, when the Deputy Commissioner himself says, because when in the tripartite meeting, everybody was present. He said detailed BC criteria must be given. And the tender referred to by my learned friend is a tender of January 24, prior to, my lord, that tripartite meeting.
No one. Actually, let me, this tripartite meeting was of 8th of August and oil tender is subsequent.
Deeply obliged.
Obliged.
For hearing, item 30.
Yeah, please, your lordships. Lordship, although this PIL is filed during the time of COVID, but here we have prayed for issuance of ration card for the marginalized section of the society, especially with regard to the 3 districts of Arunachal Pradesh, Lordship. One is Papupare, Changlang, and Namsai district, Lordship. These are the 3 districts wherein although the petitioner belongs to one of the community which is from that particular locality, but prayer is made for all the marginalized section where you. Yes, we had filed, yes, may I submit, Lordship? In our affidavit, Lordship, we have filed in our rejoinder affidavit, Lordship, where we have stated that page number 333, Lordship. They have applied for. These are the list. And moreover, as per the act, yes, Lordship, we have provided the details who has applied for ration card. It's the additional affidavit, Lordship. We have rejoinder. The rejoinder affidavit we had filed on 21/6/24, Lordship. We had provided a list which was there with the petitioner before this honorable court. Annexure 19, Lordship. Page 333, Lordship. 33. And 32 also, Lordship. Yes, Lordship. Yes, Lordship. No one has been issued a ration card, which is there. We have submitted before this honorable court, Lordship. Yes, Lordship. Yes, Lordship. Most of them are by birth Indian citizen. Although they belong to certain community, but they are by birth Indian citizen. But if they have rejected, that also is not being informed to us. And moreover, Lordship, as per the National Food Security Act, it is also the responsibility of the state authorities to identify the marginalized who under the targets. Chakwas, Hajong. Ban, but then may I submit with that regard? Then the central government affidavit is very essential for us. Central government in this case has not yet filed any affidavit. They have not filed any affidavit. Yes.
Lordship, since it's a issue, it's a question of issue of this family ration cards, Lordship, it is the state government who has to look into that. Now, whether primarily whether they have been granted citizenship or not. Now, if they are not citizens of India, naturally they will not be allowed. So far as question of giving food grains is concerned, it is not a case, Lordship. This Lordship will just remember this case was filed during the height of the COVID. That time they did have some problem. It has been settled, Lordship. It is not their case that now also they are not getting any food grain. It is true that they do not have a ration card. That we cannot give, Lordship. But it is not true that they are not getting any food grain, Lordship.
May I submit, Lordship? They are the citizen of this country. Most of them are casting vote. We have stated, and if they are casting vote, their name are enrolled in the voters list. They are entitled to.
Well, please, the affidavit that has been referred to just now, madam, has not been replied, but prior to that, we have filed, madam, number of affidavits. My lord, I am certain, my lord, these have been, my lord, the over telephone, my lord, that they have been forwarded, but at what stage those are pending, my lord, that we have to, no, my lord, at what stage, ma'am? These have been forwarded, my lord. Your lordship will kindly see page 332 is one document, my friend has annexed. Your lordship will see the prior page, annex 18. I mean, these applications were submitted to the extra excellent commissioner, my lord, who signed at the bottom. And these were forwarded to the sub-divisional food, and so I am also sure. My lord. At which stage, my lord, at what status, my lord, that I have to bring, my lord, that, but forwarded, they are not pending, my lord. Our case is that the matters have been sent to the Union of India, my lord, and it is in their ministry, my lord, the matters are pending. And unless they have citizenship, my lord, we cannot grant for citizenship.
That is different.
My lord, the ration card is not granted because they don't have citizenship. That is all.
That is critical.
My lord, these cases, my lord, this instruction, my lord, that status I have to, my lord, we have already written, my lord, that your lordship will kindly grant us some time, my lord. Some time, my lord.
Yeah, okay, so that I understood.
Wait, please. Forward for forward for.
Deep feedback.
Item 31.
Interval R5 to R8 অধিকার আছে না?
ওটা তো কি হবে ওটা আছে ইয়ে টাকা দিয়ে ভিতরটা দিয়েছিল এখন ওটা one matter a order dated 1/2/23. That 1/2/23, my. Only question was here, intrusion of some communities, non-tribal in the tribal areas. This is the case, man. Your worship will find page 37 is the MP notification. Yes. So basically the matter 160, oh, so. না একটা ভালো যাবে না কখন দেবেন So, madam, basically the purpose is for protection of the ST people in the plain areas. Man. It does not fall within 6 schedule or 5th schedule. It's a plain areas. So in 1947, this chapter 10 is added here. So our only question was the very purpose of chapter 10. This notification negates that very purpose of that here, man, because they are the advanced communities, man. And for purpose is to protect their interest, their well-being, their advancement. Madam? No, the regional minor they have to see as per 160, your worship kindly see. Affidavit, yes. I have seen the affidavit. What is the regional minor?
Your Lord kindly see now, 161, what it says, my Lord, your Lord kindly see. 160, subclause 1 and subclause 2, my Lord. Yes. The two, my Lord, the government, state government, 162 I am reading, subclause 2. The state government may, by notification in the official gazette, specify the classes of people whom it considers entitled to protection by such measure as aforesaid. Now, what is the aforesaid, my Lord? Your Lord kindly see. Yes, right, my Lord. Notwithstanding contain anything, the state government may adopt such measures as it deems fit for the protection of those classes who, on account of their primitive condition and lack of education or material advantage, are incapable of looking after their welfare in so far as such welfare depends upon their having sufficient land for their maintenance. Now you will kindly see their affidavit, the one which they filed on. As aforesaid, means, my Lord, lack of education, material advantage are incapable of looking after their welfare in so far as welfare depends upon their having sufficient lands for the maintenance. Now you will kindly see their affidavit, my Lord, what they have stated. Yes. They said what cabinet decision, etc., my Lord. Now, if we come to, my Lord, page 155. Paragraph, my Lord, C and D, my Lord. Page 154, 55, my Lord.
Running page.
Running page. D, my Lord. The subcommittee considered the historical perspective of Shadia and particularly the reasons for which most of the non-protected people in Shadia tribal belt were yet to get their land titles, showing linkage to our forebears, although they have been living there permanently prior to the formation of Shadia tribal belt. Now, what is the reason, my Lord, they are giving for which most of the non-protected people in Shadia were yet to get their land title? That is the reason they have given. First, my Lord. Now, next they are coming, my Lord, by making proper investigation. The community-wise population percentage of the aforesaid communities in North and South Shadia was ascertained. It was further found that there were suffering to the people, including aforesaid 5 communities, due to the great earthquake in 1950 and the severe floods and erosion after the earthquake adversely affected the people who lost not only their belongings, but also other relevant records and land documents. There was illiteracy and ignorance among the people for which some eligible non-protected communities lost their documents. All these factors have been duly taken note of before taking the final decision for declaring the said communities would be protected class, as would be evident from the cabinet memorandum. So basic question is, my Lord, they lost their documents because of the earthquake. Yes, illiteracy is something different, my Lord. My Lord, illiteracy is something here, lack of, my Lord, illiteracy is there, my Lord. All over India, all over Assam, we find, my Lord. In some areas, illiteracy is very less, my Lord. My concern is, my Lord, here the 160 subclause 1 say lack of education or material advantages are incapable of, that is the basic important, are incapable of looking after their welfare. I am on that one, my Lord. Yes, they may be illiterate, they might have lost the documents. I am not on that, my Lord. My question is whether this is satisfied or not. If your lordship finds satisfied, I have nothing to say, my Lord. 154. C, from the contents, that is, from the contents of the cabinet memorandum, it would appear that though the above exercise, it was discovered that due to primitive condition and lack of education or material advantage of the said community, they are incapable of looking after their welfare, and so far as such welfare depends upon having sufficient land for their maintenance. As a matter of fact, it came to light in the cabinet committee meeting that due to illiteracy, the communities in question could not get settlement of land since many of them lost their document. So basic matter substance is this one. They lost their documents due to illiteracy. The communities in question could not get settlement of land since many of them lost their land document. Now, once they are settled, this land will fall within the tribal belt. Whole purpose will be frustrated. I'm only on that, my lord. Yes, they have stated and they are primitive. This will not come here, my lord. They are advanced people, my lord. They are having MLAs also, my lord. So ultimately, advanced people, politically advanced, economically advanced, socially advanced, my lord, other literacy also there, my lord. Of course, they have stated it, my lord, but of course, it's a matter of fact. I have made a statement similar that more than I cannot say. But they have never reverted. They have never controverted that they are not advanced people. They have not ever said anywhere. No. They will be in a better position to say, my lord. They could have come with the accords, my lord. My question is, my lord, these 5 people, they were never been included. But keeping in mind that people are well-being, my lord, they are well established. That's why initially they are in 50, earthquake came in 1950, my lord. In our country, they are asking they were not in that they are not for that. And in many cases, the commissions and all. But tribal belt and block, it has created particularly this for the scheduled tribe people. Basic intentionism. Some material I lift your lordship, my lord. Your lordship on the face of the records, your lordship may decide. Instead of giving my that will be better, my lord. Because our only question was that it will negate that.
The way your lordships are responding, my lord, on the last occasion on 5th of September, the matter was heard. The Honorable Court was about to dismiss the petition, but at last they passed an order that they admit and you keep in the legal court. So your lordship may pass, my lord. I have placed the materials that a detailed procedure for 2-3 years, my lord. An exercise was undertaken to fulfill the requirement of section 160, so as to grant this protection, my lord. And I have arranged all the documents after the lordship passed an order and filed an affidavit stating the grounds on which this has been done. And it's purely a policy decision, my lord. Your lordship is aware, in a matter of policy decision, this Honorable Court will not interfere unless it is found to be arbitrary. And here is a case where an entire exercise was undertaken, a cabinet subcommittee was constituted, cabinet subcommittee went into the entire details. Then the disaster management was again engaged. They also did some exercise. Thereafter, this order was passed. The person who has approached this Honorable Court, he has approached with a, my lord, different agenda.
No, they are not.
My lord,
they are social worker.
My lord, he has not shown in the writ petition whether ever before he did anything for the society. He has simply, my lord, what is his locus?
Yes, I have given.
He has got absolutely no locus
I have
to
stated
challenge this kind of executive order involving policy decision, my lord. I can cite, my lord, 2-3 judgments on that, my lord. SP Gupta's case and all, my lord, I have brought all those cases, my lord. My lordship may dismiss this petition. I mean, lordship may dismiss this petition.
Now we approve the government also, my lord. They have never responded also, my lord. We filed a details representation also.
And
they have never said
as your lordship has pointed out, my lord, in the writ petition, there is nothing. They have not shown it. Now, after I filed the affidavit, now they are arguing. In the writ petition, there is nothing that the decision taken with so much of details and, my lord, background is wrong.
Nobody has pointed out, my lord. Intervener, my lord.
Leave the order.
Come. Item 32 to 34.
May it please your lordship. Lordship, I appear for the appellant in item number 32 and for the respondents in item number 33 and 34, lordship. Last evening, lordship, the nephew official sent across a message to us telling us that to seek some time, lordship, as they have proposed an OTS with the JSB Cement, your lordship. But asked us to take some time, lordship, so that they can proceed with the OTS, your lordship.
No, so for Punjab National Bank, my lord, the OTS failed. So my lord, on 22/10/2024 was the last date they could not pay. So I told my learned friend, he is the most resourceful advocate amongst us. He can help his client by lending them something.
Well, I can issue the check, whether it bounces or not, that is a different thing.
Then.
My lord, the three-party agreement which was reached, my lord, that was the date was 22nd. In fact, the date, 2 days time was granted, because the finance has to come from somebody third party, my lord. So accordingly, my lord, it has been extended to 31st.
31st, your lord.
So, my lord, instead of fighting all those things, if the, my lord, settlement is going on, it's better that 2 weeks time will be granted so that, my lord.
My lord, we want our money only. But then OTS, yes, my lord.
Lord.
Well,
That will be 2 weeks, my lord, so that, my lord. Well, because ultimately, if the settlement is there, then the things can be sorted out, my lord. All the 3 cases.
obliged.
I am applying.
Item 35.
There is an entry model in 33 that we continue. My lord.
See, that Sine is on legs, lordship, he's probably coming, lordship. Can it be taken as a last matter?
If he speaks any other day, my lord, ask is any other day, please on legs. It's a difficult thing. After Diwali, after 11, no? Yes, after 11, any day.
1911.
19.
Like that.
Nine.